Hello and welcome. Today I would like to talk about diversity inclusion in the employment opportunity laws, which is important in any sector of our industries in the United States, as well as when we're working abroad in foreign nations. The concept of diversity can be very beneficial to work groups and organizations alike. Diversity basically describes the real and perceived differences among people with respect to their gender, race, ethnicity, age, physical and mental abilities, sexual orientation, religion, and other attributes that may affect their interaction with others. So diversifying a group is no guarantee for immediate success, but nonetheless, it is a necessity for innovation, for creativity, for outperforming the homogeneous teams. Diversity's potential is usually unlocked when diversity is accompanied by inclusion. If you diversify a group, it does not always produce better outcomes. As a matter of fact, it might lead to more conflict. However, effective teams that are managed effectively by themselves are likely to outperform their homogeneous counterparts. So the key benefit of diversity is that it is critically essential for creativity and innovation. And diversity actually affects a company's reputation and overall performance in the industry. So it can impact what type of people want to apply for your company and work for your company, and whether they stay there for a long period of time. Research has consistently showed that diverse teams that are managed well always tend to outperform homogeneous teams that are managed well. So the goal here would be to produce better outcomes through diverse teams, simply because they can be thinking differently, more innovatively, more creatively. And if you're not getting that, that means the team needs more development, more communication skills, more conflict management skills, and more inclusion within their team members. Why is diversity and inclusion still a challenge to achieve for us in the United States, when in fact we've been talking about this for over 6 decades? There has been a lot of laws introduced, right? Well, there might be many, many reasons, but some of them include the similarity-attraction-tendency of people to prefer other colleagues and individuals who are similar to them. So in other words, my natural tendency would be to work with people who look like me, think like me, speak like me, are of the same age as me, same generation as me, same height as me, and play similar games as me or similar hobbies. So the similarity-attraction-tendency, unfortunately, is a barrier to inclusion in diversifying teams. Also, people tend to establish trust more quickly, show willingness to cooperate, and experience smoother communication with others who are similar to them. So these are natural tendencies that we all have. The more we become aware of them, the more we can hopefully not allow them to prevent us from diversifying our teams and also from being inclusive in everything we do. So the similarity-attraction tendency is a barrier to hiring employees who are different from the existing pool of candidates that we have working in the department. The tendency of similarity-attraction manifests itself as perceived chemistry or gut feeling. So gut feeling alone is not sufficient to make a decision regarding hiring and diversifying. We need to go beyond the gut feeling by providing numbers that show and demonstrate the diversity of your teams, as well as numbers that you can show in a court of law that you're going in the right direction. You've always had good intention of diversifying your teams, and you are basically complying with the law, and oftentimes have been going above and beyond the law compared to others in the market. And there are also stereotypes and biases that you and I as individuals hold that reside beyond our conscious awareness. We call those unconscious or implicit bias. The use of assumptions and generalization when making decisions about individuals can lead to unfair as well as potentially illegal decisions. This is why it's so important to avoid going with your gut feeling. We need to make objective, data-driven decisions when it comes to hiring, when it comes to promotion, when it comes to interviewing, when it comes to recruitment, and when it comes to forming various teams. We need to prevent these biases. We can only do that by becoming aware of our own biases and how it might impact our decisions. We need to avoid and prevent biases from impacting our decisions when it comes to selecting or diversifying groups and teams or our departments. But in order to do that, we need to be aware of our biases. And perhaps we can have blind auditions and blind applications. Of course, that's not always realistic, but nonetheless, we need to avoid looking for information that confirms a person's age or religion or gender, et cetera, so you can make decisions solely by qualification and how good of a fit a person is to your existing pool of workers in the department. We need to do all of this by data. We need to do this by numbers, by analysis. Why? Because it's the right thing to do. And secondarily, it is required by Equal Employment Opportunity Laws, or EEO laws. The aim of these Equal Employment Opportunity Laws is to prevent discrimination against employees, against job applicants, against trainees and apprentices, or those who are qualified for a promotion, for pay raises, and so on. EEO laws cover business, private employers, and government agencies with 15 or more employees at any given time. EEO laws require applicants and candidates to file a complaint with the Equal Employment Opportunity Commission as the first step within a certain time when they feel that they're being discriminated against because of their age, gender, sexual orientation, religion, or other protected categories. And it can apply to all aspects of the employment relationship that they might have from the beginning of their employment life cycle all the way until employees transition into retirement. EEO laws forbid retaliation against those involved in discrimination claims against your department or management or organization. The Title VII of the Civil Rights Act prohibits employment decisions based on protected categories such as national origin, religion, race, or gender. It also prohibits both intentional discrimination as well as seemingly neutral decision criteria that have a discriminatory effect or adverse effect or a disparate impact on a protected group. So the Title VII of the Civil Rights Acts apply to all employers, again, with 15 or more employees, including state and government institutions. Be mindful, know your numbers, and comply with all the laws. Harassment can be any unwelcome behavior based on sex, race, religion, national origin, and other protected categories that should be avoided at all costs, not just because of legal requirement, but also because of productivity, because of teamwork. You cannot have inclusion if a specific individual or group of individuals are being harassed simply because of their age or national origin or religion. More specifically, sexual harassment describes those unwanted advances in other harassment that is sexual in nature. You can have quid pro quo or this for that, or you can have a hostile work environment where some conducts are being repeated over time and a reasonable person would find them offensive. That means there's a hostile work environment that could get your company into trouble. You also need to be aware of reverse discrimination, that is discrimination against majority or historically privileged groups. Through inclusion, we can avoid compensatory or punitive damages. Compensatory damages provide financial relief to the complainant for damages incurred such as mental or emotional stress that was suffered as a result of the discrimination that they experienced in the department. And punitive damages usually are awarded if it is demonstrated through evidence that the company had engaged in reckless discrimination and they failed to act in good faith to prevent any discriminatory practices or harassment issues. You can also sometimes, unfortunately, see class action lawsuits where groups of individuals who have similar claims are suing as a group the organization. They claim gender discrimination or racial discrimination or age discrimination, and it could be a few people or it could be hundreds and thousands of people, as we've seen in major cases over the past few decades. You also need to be aware of additional anti-discrimination acts and protections. For example, the Pregnancy Discrimination Act of 1978 prohibits discrimination against employees due to pregnancy or related conditions. You have the Age Discrimination Employment Act of 1967 that protects older workers who are 40 years of age or above. You have the Americans with Disabilities Act of 1990. You have the Genetic Information Non-Discrimination Act of 2008. You have the Lillian Ledbetter Fair Pay Act of 2009. And also, as you have seen from the Supreme Court decision of the last few years, we have protections for the LGBTQ workers. So we have to be concerned about diversity and inclusion in the age of people analytics. You can use data analytics to describe your current events or current situation in the organization. You can use it to make predictions about the future trends if you continue doing exactly what you've been doing. As always, you and I need to build a reputation for being an objective, analytic, and a rational professional. So you can analyze the numbers, the data, and all of the facts surrounding every situation to make evidence-based decisions. You can do it. Good luck.